Hello everyone, it's me, Leonard French, your favorite copyright attorney. Today I want to go over a really interesting problem that the United States has encountered with the Affordable Care Act intersecting with concepts of federalism. I know, at first that sounds like a very boring topic, but I promise you it's way more interesting when properly understood. This is important. The outcome of the case will determine whether millions of Americans have health insurance and whether millions of those covered enjoy protections for their pre-existing conditions. So grab a bag of popcorn and buckle up. I'm going to try and explain what's going on. If you weren't around for the days before protections for pre-existing conditions, you might want to know why it's so important. If you think about insurance companies as private entities with a for-profit motive, then they make the most money when they collect your insurance premiums and pay out as little as possible. Any insurance company is highly motivated to deny as many claims as they can. One of the myriad ways health insurance companies maximize their profits is by denying coverage for pre-existing conditions. A pre-existing condition is a medical condition that existed before you started your health insurance coverage with that company. On one hand, it makes some sense. Why should an insurance company cover your medical expenses for a condition that began before you obtained insurance coverage? Thus, if you have a pre-existing condition while applying for health insurance, you may find your premiums unaffordable, or your coverage denied outright with no recourse and no coverage. But almost everyone needs healthcare coverage. The costs of medical care are beyond the reach of most Americans as prices have dramatically risen in the past few decades. And medical issues distract otherwise hardworking people from earning money and paying taxes on those earnings. Large enough medical issues make the person dependent on their state's welfare system, draining taxpayer funds instead of contributing to them. When a person can overcome their medical issues, they can return to work, return to earning money, and return to contributing to the tax base, further enriching the social welfare of every American. It's well known in the United States that a single minor medical issue can cost so much money as to drive a person or family into bankruptcy. About 67% of personal bankruptcies in the United States are caused primarily by medical debt. Imagine, instead of a minor medical issue, you have a major one, and your inability to afford the bill is highly likely, leading to a virtually guaranteed bankruptcy. Two quick examples. When I was a bit younger, I had a friend with a lung condition. Without a lung transplant, she would have certainly died at a young age. But she could not afford the lung transplant. At least not until the Affordable Care Act ensured that her lung condition would be covered by a health insurance plan obtained after she was diagnosed with the condition. Because of the Affordable Care Act, she was able to obtain a lung transplant and lives a normal life to this day. Second example, the president's recent coronavirus infection led to a 3-day stay in Walter Reed Medical Center. Although only a stay of 3 days, and only receiving treatment for the coronavirus, the bill, translated to what a common citizen would receive with similar care, was estimated to be over $100,000. For most Americans, a bill of over $100,000 would lead to financial ruin, and financial ruin is a self-perpetuating prophecy. People who get stuck with medical ailments, the bills from them, and little prospect for overcoming the financial consequences are stuck in personal and financial ruin for the foreseeable future, sometimes for life. Compassionate people, empathetic people, understand that this is not maintainable. The Affordable Care Act was passed by Congress and signed into law by President Obama on March 23, 2010. Its major goals were to make comprehensive, complete health insurance coverage available to everyone. It did so by requiring everyone to have health insurance, the idea being that if everyone paid in, then that would offset high premiums by socializing the costs, a method implemented in one way or another in at least 32 countries and partly implemented in many more. Among the ACA's major provisions were protection for pre-existing conditions, as well as government-paid subsidies for those who could not afford the full cost of their premiums. There were many other parts to the law, but I'm trying to summarize. The law was quickly challenged in court. The 2012 case of National Federation of Independent Business versus Sibelius challenged Congress's power to pass and enforce the Affordable Care Act. This is where things get complicated, but can be simplified with a basic understanding of concepts of federalism. The United States Constitution's 10th Amendment is America's founding fathers' attempt to express the shared power between the sovereign states and the sovereign federal government. The 10th Amendment says, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people." In this clause, the United States means the federal government, the central government created by the union of the several states. Although Americans as we know them declared independence from British rule on July 4, 1776, a less well-known date is when the United States Constitution was actually written and put into force. Before March 4, 1789, the United States was not governed by the Constitution as we know it. It was instead governed by the Articles of Confederation, written in 1776 and 77, and ratified in early 1781. Before that, what we now know as individual states were basically just 13 separate colonies in part of the geographic region that we now call the East Coast, minus Florida and Maine. Those 13 colonies each considered themselves to be sovereign nations. Though we consider ourselves unified today, American colonists were not so unified in the beginning. The individual colonies did not want to give up all their power to a central government, a federal government, but recognizing the principle embodied in "united we stand, divided we fall," America's founding fathers put their heads together and developed a way to preserve the colonies' sovereignty while also uniting them under a central federal government. This is a vast oversimplification, and I highly recommend that you read some of the links in the description below if you want to know more about the history of the formation of the United States. For the purposes of our discussion, it is important to understand a few basic concepts of how America's founding fathers attempted to preserve both states' rights and unification under a federal central government. First, the unifying Constitution divides the operation of the federal government into three branches: the legislature or Congress that makes laws, the executive branch or president that enforces and faithfully executes laws, and the judicial branch, which adjudicates legal disputes and interprets the will of the legislature or Congress in creating laws bounded by and based on the Constitution. Second, this unifying Constitution divides the representation of the several states into two chambers of Congress called a bicameral Congress. The House of Representatives assigns members according to each state's population. The United States Senate assigns 2 representatives to each state. America's founding fathers believed this was a proper balancing of the representation of the population and the representation of the individual states. Laws can only be enacted through what's called bicameralism and presentment, the process of both chambers of Congress passing a law and then presenting it to the U.S. President for signing or veto. A backup method was enacted allowing a supermajority vote of both chambers of Congress to pass legislation without the president's signature if the law passed by a 2/3 majority of both chambers. Third, and most importantly to our discussion of the ACA, the powers of the U.S. Congress to enact legislation are limited, as we discussed briefly when I described the 10th Amendment. The United States Constitution grants some powers to the federal government and leaves all other powers to the states. While the U.S. Congress can write and pass any law, the judicial branch will only enforce and can strike down any law that is outside of the powers of the U.S. Congress. That means Congress's power is limited to only those powers specifically given to it in Article 1, Section 8 of the U.S. Constitution. These are called the enumerated powers. Among these powers are the power to impose and collect taxes on behalf of the central government and to regulate interstate commerce. But remember that 10th Amendment? The powers not given to the central government are left to the states. The states are still allowed to collect their own taxes and regulate their own intra-state commerce or internal business. This means the federal government is powerless to regulate commerce that does not cross state lines. The basic regulation of health, safety, and welfare is shared between the states and the federal government. Where the regulated activities cross state lines, the federal government's power to regulate interstate commerce allows it to enact any law that has a rational basis. Where the regulated activities do not cross state lines, the federal government has no power, and the power to regulate falls to the individual states. And there's no requirement for states to have a uniform system of laws where the state has the sole power to regulate an activity. This means that health insurance coverage and medical care are traditionally state-regulated activities. Because they are activities within the powers of the individual states to regulate, that means the federal government has little power to tell the states what to do in matters of health insurance and medical care. In the 2012 case of National Federation of Independent Business versus Sebelius, the United States Supreme Court was asked to determine if the Affordable Care Act was constitutional, as either a valid exercise of the federal power to regulate interstate commerce or the federal power to tax and spend. The majority opinion, authored by Chief Justice John Roberts, held that Congress's power to regulate interstate commerce does not extend to the regulation of economic inactivity. Justice Roberts said that the Act's individual mandate requiring everyone to buy health insurance is unconstitutional under the interstate commerce power because that power cannot be used to order individuals to engage in economic activity, but instead is limited to allowing the federal government to regulate existing interstate commerce activity. The late Justice Ginsburg dissented, saying that uninsured people substantially affect interstate commerce and, without insurance, they consume billions of dollars of healthcare products and services each year, products and services that are produced, sold, and delivered largely by national and regional companies who routinely transact business across state lines. The uninsured themselves also cross state lines to receive care. The majority opinion, including Justice Ginsburg, did conclude that the Affordable Care Act was constitutional, based on the federal government's power to tax and spend. Whether you agree or disagree with the majority or the dissent is of little meaning. The decisions of the U.S. Supreme Court are final and can only be overturned by act of Congress or future Supreme Court rulings. Fast forward now to 2017, when President Trump's Tax Cuts and Jobs Act reduced the Affordable Care Act's tax penalty on those who refuse to buy health insurance to zero, eliminating it altogether. Those who do not have health insurance no longer receive a tax penalty for their failure to abide by the law. Whether this elimination of the ACA's tax penalty also eliminates the federal government's power to enact the law is currently before the U.S. Supreme Court. As we've covered here on this channel, both a Texas federal district court and the Fifth Circuit Court of Appeals have ruled in favor of eliminating the entire Affordable Care Act on the basis that the zeroing of the ACA's tax penalty means the act has no basis in federal law. If the Supreme Court rules that the Affordable Care Act is no longer a valid exercise of federal legislative power, it could eliminate the entire law altogether. But this is a somewhat controversial view. There are many political opponents of the Affordable Care Act, known as Obamacare, because it represents a major achievement of President Barack Obama. These opponents generally want to see the law struck down and the power to regulate health insurance left to each individual state. But the Supreme Court has another way to adjudicate the case, which is somewhat more confusing, but also somewhat more likely. You may have heard about the severability doctrine. This is the public policy preference of the Supreme Court preferring to uphold the intent of the legislature. Instead of the court striking down entire laws because of one provision's unconstitutionality, the court will often declare only one provision unconstitutional while keeping the remainder of the legislation intact. Roberts explained the severability doctrine in Salah Law versus Consumer Financial Protection Bureau, saying, "We try to limit the solution to the problem, severing any problematic portions while leaving the remainder intact. We will presume that Congress did not intend the validity of the statute in question to depend on the validity of the constitutionally offensive provision unless there is strong evidence that Congress intended otherwise." The severability doctrine asks the basic question of whether Congress would choose not to pass a law if it knew that one provision was unconstitutional. Applied to the Affordable Care Act, the question is whether Congress would have passed the Affordable Care Act without the tax penalty on those who don't buy health insurance. Sometimes Congress provides severability clauses in legislation to tell the court what they intend to happen should a provision be found unconstitutional. The act in the Salah Law case was easily upheld because Congress expressly said, if any provision of this act is held to be unconstitutional, the remainder of this act should not be affected. But these clauses are discouraged by Congress's manuals of drafting legislation. Many statutes, including the Affordable Care Act, don't have them, leaving the interpretation of Congress's intent to the justices of the U.S. Supreme Court. Upholding congressional intent is the norm and a usually uncontroversial analysis. But we don't live in uncontroversial times. The internet, once a bastion of knowledge and growth and hope, is now also a haven for misinformation. Complicated, massive topics like concepts of federalism and the doctrine of severability are too heavy to bubble to the top and to be easily seen. Instead, we must dig, research, and analyze to understand what's really going on. It is our duty as citizens to be educated voters, to vote with our minds fully informed, instead of shooting from the hip based on headlines and hoaxes. Whether the U.S. Supreme Court upholds the remainder of the Affordable Care Act is solely in the hands of the sitting justices. The fact that Amy Coney Barrett refuses to answer questions about how she will rule is not surprising. Judges are not supposed to foreshadow how they expect to rule outside of the courtroom and before being fully informed themselves. While I expect that Judge Barrett understands the issues, it is inappropriate for her to foreshadow her ruling in Senate confirmation hearings. Your power as U.S. citizens to affect the survival of the Affordable Care Act lies solely in your power to influence your congressional representatives, the legislature that makes the laws. Your power to affect the confirmation of Judge Barrett to the U.S. Supreme Court lies solely in your power to influence your senators to confirm or deny her appointment. Your power to decide how your medical care and health insurance coverage is regulated lies solely in your decisions choosing your representatives in the House and Senate, the bicameral chambers of Congress, the legislature who makes your laws. Your power, my friends and countrymen, lies in your vote.